Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. This one's short. In the United States, we have 3 primary standards of proof, or in other words, standards for proving the allegations made in a legal case heard in a court of law, whether a civil or criminal case. Those standards of proof are, in order of the lowest standard of proof to the highest standard of proof, preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt. Although this video will be short, I will cover each of those in a moment. We have to clear up a few terms first, so a quick term within our 3 main terms. Factfinder. We need to know who that is. In all trials, whether civil or criminal, there is a finder of fact, or a fact finder, same thing, who listens to the witnesses testify and who views the evidence in a case and decides what is true and what is not true. The fact finder can either be the jury, which is what most of us are familiar with, a jury who decides whether they believe witnesses and other evidence, or for parties who prefer to try their case in front of a judge, just the judge. Yes, in some cases, a defendant can skip the jury and just ask a judge to hear their case and be the fact finder or finder of fact. In those cases, the judge determines what is true and what is not true. So, in a nutshell, the fact finder can be either the jury or the judge. Another quick term within our terms, meeting the burden of proof. To meet the burden of proof means that a party has provided enough evidence to clear the threshold for whichever standard of proof applies to their case. So first we need to know which standard of proof applies. Then the party raising the allegations has the burden to meet the standard of proof. In civil cases, that party is the plaintiff, the complaining party, which makes sense. The person who files the claim has to then prove the allegations in the claim. In criminal cases, that party is the prosecutor, the one bringing the charges. There are a few legal procedures that sometimes result in the burden shifting to the other side, but we don't need to review those instances to cover the meanings of the standards of proof. The standards don't change even if the burden to meet the standard of proof can occasionally shift. So to sum up this first part, the terms are standard of proof and burden of proof. Generally, we ask, what is the standard of proof? And the answer would be either preponderance of evidence, clear and convincing evidence, or beyond a reasonable doubt, which again I'll explain in a moment. Then we ask, who has the burden of proving their case in accordance with the applicable standard of proof? Or more simply put, the burden of proof. So there are 2 things at play. We have a standard of proof, and then we have a party who has a burden of proving their case according to the applicable standard. Over the years, though, legal society has collapsed the 2 concepts into one and just called all of it together the burden of proof. So the question, what's the burden of proof, can mean either what is the standard of proof or who has the burden of proof. The burden of proof is used interchangeably at this point. For this video, I'm going to use standard of proof for the standard and burden of proof for who has the burden to keep it all straight. But if you're trial watching, just know that you're going to hear often the burden of proof, and it will mean the standard, the burden, everything all together in one term. And then remember, it is the fact finder, the jury or the judge, who must decide whether the party who had the burden of proof met the applicable standard of proof when the trial is done. So, fact finder, standard of proof, burden of proof. Okay, on to the actual standards of proof. A preponderance of the evidence is the standard of proof applicable in civil trials. The plaintiff, the person suing, can meet the burden of proving their case in accordance with the preponderance of evidence standard if the plaintiff can convince the fact finder, whether a jury or a judge, that there is a greater than 50% chance that the claim or claims in the lawsuit are true. That's it. If the evidence tips in the plaintiff's favor more than 50% by just a feather, a preponderance of the evidence, the fact finder can find in plaintiff's favor. A typical claim with the preponderance of evidence standard of proof is a personal injury claim, where the plaintiff need only prove by a preponderance of evidence that the defendant caused the injuries. The clear and convincing evidence standard of proof applies to civil cases, but can also apply to certain types of criminal activity that may factor into civil claims. For example, certain types of fraud committed to perpetrate the other activity that forms the basis for the civil claim. For the clear and convincing evidence standard of proof to be met, the fact finder has to find that there is a high likelihood that the evidence is true. There can be room for doubt, even doubt that is not reasonable. Like, I saw enough evidence to believe the uncle forged the will. That's enough for me. But if the party who has the burden of proving their case in accordance with the clear and convincing evidence standard of proof can show that the scale carrying the evidence, including any doubts, still tips very heavily in favor of the evidence likely being true, that party will have met or carried their burden to prove their case in accordance with the clear and convincing standard of proof. Burden of proof, standard of proof. An example of a claim with the clear and convincing evidence standard of proof is a civil claim that seeks punitive damages in addition to regular damages. Punitive damages are awarded when a civil defendant has engaged in oppression, fraud, or malice. The clear and convincing standard of proof may also apply in more general fraud cases, such as alleged fraud surrounding the finalization of a will, or the circumstances surrounding the withdrawal of life support. The beyond a reasonable doubt standard of proof is the one we likely know best. It applies to criminal cases and is the highest standard of proof and therefore carries the heaviest burden of proof. Proving the allegations in a criminal case beyond a reasonable doubt means that any other reasonable explanation for the crime or crimes to have been committed has been ruled out by the evidence presented in the case the fact finder is considering. Note that the doubt must be reasonable. Let's say a business has a window near its backdoor alleyway entrance and that window is bashed in on purpose by a criminal perpetrator. Let's say a defendant on trial for bashing the window was caught on video carrying a hammer in the alley near the window. No person or video cameras saw them bashing the window, but they were caught on video carrying the hammer near the window. After hearing the evidence, the fact finder cannot say, well, technically, a boomerang flying in from Hawaii could have broken the window in New York if it traveled on an airplane's tailwind, so maybe it wasn't the defendant who was caught on video carrying a hammer in the alley near the window. That won't suffice as a reasonable doubt. But if there's any other reasonable explanation for the crime or crimes, like evidence of kids throwing rocks in the alley near the window on the same day it was broken, arguably there is a reasonable reason to doubt the defendant is actually guilty, and the prosecutor's burden to prove the case according to the beyond a reasonable doubt standard of proof has not been met. And this is key. Under the Fifth Amendment to the U.S. Constitution, if there really is reasonable doubt, the fact finder may not say, well, I still believe the defendant did it, so let's just convict that person. If evidence shows there's reasonable room to believe that the defendant did not do it, in other words, if there's reasonable doubt that the defendant did it, according to the U.S. Constitution, the fact finder must acquit the defendant and may not convict the defendant. And there you have it, the standards of proof. If this was helpful, please hit that like button. Links to my other trial watchwords are above and in the description, or you can simply let the playlist roll. Links to my traditional channel material are also in the description. And it bears repeating, nothing in this video is intended to be legal advice to anyone about anything. Thanks for watching.